Hello. Okay. Class, we are now on the fourth PowerPoint presentation for the prelim. This in regards to the extinguishment in a contract of. But before that, we would like to credit to the following researchers. For this PowerPoint, we have Judivine Discipolo, Benchip Rodriguez, Josette Galvez, Miss Ochabelio Tisa, Romnick Ihos, Miss Kaday, and Cassandra Latonet. So, as usual, we have to have the pre-test or post-test questions. One question is, what is pledge? Number 2, what is mortgage? Number 3, what is the right of the creditor? What is the right of creditor when debtor fails to comply with his obligations? What are the exceptions of the rule of indivisibility? Number 5 question is, what is the characteristics of a contract of mortgage? Number 5, what is prohibited by Article 2088 in connection with Pactum Commissorium? Explain Article 2089 of the New Civil Code. Distinguish pledge and real mortgage. Question number 8. Question number 9, what is the similarity between pledge and real mortgage? And question number 10, under the promise to sell, can a mortgagor validly sell a property to the third person in payment of the obligation? Now let us answer this. Question number 1, mortgage, otherwise known as real estate mortgage or real mortgage, is a contract whereby the debtor secures to the creditor the fulfillment of a principal obligation, especially subjecting to such security immovable property or real rights or immovable property, which obligation shall be satisfied with the proceeds of the said sale of property or rights in case the said obligation is not complied with at the time stipulated. Now, what is pledge? Pledge is used for movable assets. In cases where the obligor, the debtor, breach his or her obligation, he or she shall be liable for damages. A breach of contract occurs when one party is in a binding agreement fails to deliver according to the terms of the agreement. Number 4, where each one of the several things guarantees a determinate portion of a credit and where only portion of a loan was released. Number 3, where there was failure on consideration. Number 4, there is no debtor or creditor relationship. The number 5 question, it is a real, accessory, and subsidiary contract. It is also unilateral because it creates only an obligation on the part of the creditor who must free the property from the encumbrance once the obligation is fulfilled. Number 6, it is the automatic appropriation by the creditor of the thing pledged or mortgage upon failure of the debtor to pay his debt within the period agreed upon by virtue of authority or right previously given to the creditor. Number 7, explain Article 2089. Pledge or mortgage is indivisible, even though debt may be divided among accessories in interest of the pledge or of the creditor. Number 8, differentiate pledge and mortgage. Pledge methods of creating a charge over movable property or asset and applied on the movable property such as gold, shares, insurance policies, national savings schemes, etc., while mortgage is a method of creating a charge over a movable property or asset. It's applied on anything which is fixed attached to the earth, land and building, house, plant and machinery, etc. Number 9, what is the similarity? They have the similarity to making an agreement of a contract for reliability and as a guarantee for debt payment. Yes, question number 10, because a promise is merely a personal obligation of okay, let us one by one. What is pledge again? Pledge is used for movable assets. It is a method of creating a charge over a property or asset It is a bailment of goods as security of a promise called a pledge. And it is applied on a movable property such as gold, shares, insurance, policies, national savings schemes, while mortgage is a term that is used for immovable assets. Mortgage is a method of creating a charge over immovable property or asset. It is applied on anything which is fixed or attached to the earth. Example, land and building, house, plant and machinery, etc. It is a secured loan that allows you to avail funds by providing an immovable asset, such as a house or commercial property, as collateral to the lender, and the lender keeps the asset until you repay the loan. They have the similarity to making an agreement or a contract for reliability as a guarantee for debt payment, pledge and wills. Right of a creditor, where debtor fails to comply with his obligation. In cases where the obligor or debtor breach his or obligation, he shall be liable for damages. A breach of contract occurs when one party in a binding agreement fails to deliver according to the terms of the agreement. If the debtor fails to perform obligation to do, the creditor may compel the debtor to comply with the obligation. If an obligation to do has been poorly done, the creditor may have the same be undone at the expense of the debtor. As a general rule, the debtor incurs in delay if he does not perform his obligation on the date it is due. That is the right of a creditor where debtor fails to comply with his obligation. Now, if the obligor debtor does not do something that it was not obliged to do, then it shall be enforced at its own expense. Now, there is a provision against pactum commissorium. It's called stipulation that is null and void. No? A stipulation whereby the thing pledged or mortgage shall be automatically become the property of the creditor in the event of non-payment of the debt within the term fixed is known as pactum commissorium, which is forbidden by law and declared null and void. So that is the definition of commissorium. What are the requisites of pactum commissorium? There are two requisites or elements for pactum commissorium to exist, namely 1 or A, there should be a pledge, mortgage or anticrisis or property by way of security for the payment of the principal obligation, and should there be a stipulation for an automatic appropriation by the creditor of the property in the event of non-payment of the obligation within the stipulated period. These are the two requisites of pactum commissorium. Stipulation proposed existence of security contract, number 3, referred to in Article 2088 and 2137, therefore presupposes the existence of a mortgage or pledge or that an anticrisis that thus it has been held that there was no pactum commissorium where pursuant to the contract of sale, the sums already paid by the vendor were forfeited for his failure to pay the stipulated installments in due time, considering that the person to whom the property was forfeited was the real and equitable owner of the same, because title would not pass until payment of the last installment. Number 4, effect on security. The vice of nullity which initiates such stipulation does not affect substantially the principal contract of pledge, mortgage, or anticrisis with regards to its validity and efficiency for the reason that the contract having been perfected. Prohibition refers to stipulation authorizing automatic appropriation. What is prohibited by Article 2088 in connection with pactum commissorium is the automatic appropriation by the creditor of a thing pledged or mortgage upon failure of the debtor to pay his debt within the period agreed upon by virtue of authority or right previously given the creditor. Thus, Stipulation providing that the mortgage property shall be considered in full payment without further action in court in case of non-payment is null and void, being in the form of pacto commissorio. Number 2, a stipulation in a purported pacto de retro sale that the ownership of the property sold would automatically pass to the vendee in case no redemption was affected within the stipulated period. Now, permissible stipulation. Subsequent modification of original contract. The stipulations that are prohibited by Article 2080 and 2137 or anticrisis are those executed or made simultaneously with the original contract, not those subsequently entered into. The principle does not prohibit modification of the original contract by subsequent agreements such as the parties may see fit to adopt. Number 2, subsequent voluntary cession of property. The prohibition does not include a subsequent voluntary act of the debtor making the cession of the property mortgage in property of the debt which amounts in its legal effect to a novation of the original contract and to a voluntary sale of the said property for the amount of the debt. Promise to assign or sell. The promise is merely a personal obligation of the mortgagor and does not in any way bind the property. Number 4, authority to take possession of property upon foreclosure. A stipulation authorizing the mortgagee for the purpose therein specified to take possession of the mortgage premises upon foreclosure of the mortgage is not repugnant to either Article 2088 or Article 2089. A pledge or mortgage is indivisible, even though the debt may be divided among the successors in interest of the debtor or of the creditor. Article 2090. The indivisibility of a pledge or mortgage is not affected by the fact that the debtor are not solidarily liable. Now, pledge or mortgage indivisible. A pledge or mortgage is one indivisible as to the contracting parties as a rule applies even if the obligation is joint and not solidary. Found in Article 2090, 1207, 1208. Now, exceptions to the rule. Where one of the several things guarantees to determine portion of credit, or where only portion of loan was released, or where there was failure of consideration, or where there is no debtor-creditor relationship. Now, foreclosure of mortgage constituted on several properties. A mortgage, even if constituted on 2 or more properties, is one and indivisible. That is, it cannot be divided among the different properties, and the mortgage has the right to save the properties either by both jointly or singly. Sold to satisfy his claim. Further, the sale of the mortgage's property cannot be set aside in the absence of evidence to show that a better price could have been obtained if they were sold separately, or the sale of one or some alone would bring sufficient proceeds to pay. Now, where real mortgage and chattel is in one instrument, the mere embodiment of a real mortgage and a chattel mortgage in one document does not have the effect of fusing both securities into an indivisible whole. Both remain distinct agreements, differing not only in the subject matter of the contract but also in the governing legal provisions. The mortgagee therefore may legally foreclose the real estate mortgage extrajudicially and waive the chattel mortgage foreclosure and maintain instead a personal action for the recovery of the unpaid balance of the credit. Article 2091. The contract of pledge or mortgage may secure all kinds of obligation, be they pure or subject to the suspensive or resolutory. All kinds of obligation can be secured by pledge or mortgage. Any kind of obligation, whether pure or conditional, may be secured by a contract of pledge or mortgage. The same applies in guarantee, which may also secure a conditional obligation. Article 2053, see Articles 2086 and 2052. The pledge agreement may stipulate that the pledge will also stand as security for the any future advancement or renewals thereof that the pledger may procure from the pledge. Now, Article 2092, a promise to constitute a pledge or mortgage gives rise only to a personal actions between the contracting parties, without prejudice to the criminal responsibility incurred by him who defrauds another by offering in pledge or mortgage as an unencumbered things which can he knew were subject to some burden, or by misinterpreting himself to the honor of the same. Now, promise to constitute pledge or mortgage creates no real right. A promise to constitute pledge or mortgage, if accepted, gives rise only to a personal right binding upon the parties and creates no real right in the property. What exists is only a right of action to compel the fulfillment of the promise, but there is no pledge or mortgage yet. Now, criminal responsibility of pledger or mortgagor. A mortgagor or personal property shall not sell or pledge such property or any part thereof, mortgage him without the consent of the mortgagee in writing on the back of the mortgage, on the margin of the record thereof in the office where such mortgage is recorded. To mortgage, Article 2124. Only the following property may be the object of a contract of mortgage: 1. Immovables. 2. Alienable rights in accordance with laws imposed upon immovables. Nevertheless, movables may be the object of a chattel mortgage. 1170. What is mortgage? Mortgage, otherwise known as real estate mortgage or real mortgage, is a contract whereby a debtor secures to the creditor the fulfillment of a principal obligation, especially subjecting to such security immovable property or real rights over immovable property, which obligation shall be satisfied with the proceeds of the sale of said property or rights in case the said obligation is not complied with at the time stipulated. What are the characteristics of mortgage? It is real. It's a real contract, meaning perfected by delivery. It's an accessory. It is a subsidiary contract. It is also unilateral because it creates only an obligation on the part of the creditor who must free the property from the encumbrance once the obligation is fulfilled. The essence of a contract of mortgage is that a property has been identified or set apart from the mass of the property of the debtor mortgagor as security for the fulfillment of his obligation in case of default payment. And lastly, thank you for